Lordship, this matter has been settled between the parties and it will be withdrawn. And there is a warrant, Lordship. Warrant will be discharged.
Please take down the
Instruction.
learned cause for the petitioner state that the matter has been settled, amicably settled between the parties. She wishes to withdraw the present petition. The same is dismissed as
The
very
instruction will.
remote. Thank you.
Lordship, I'm praying for a short Passover. I'm being led by Mr. Banerjee. He's on his way, Lordship. If your Lordship may kindly grant a 10-minute short Passover.
In the morning, as it is, the court sits only for you because nobody is here at 10:30.
Just a short Passover, Lordship. Obliged, Lordship. Obliged.
My lord, in this matter, I appear for the petitioner, my lord. I saw yesterday she was appearing in this matter. It's a 29A, my lord. If my lord be pleased to take the section 11 order, my lord, it was a consented appointment. So hence they must not.
They are opposing it.
My lord, last day they were not opposing. They only submitted that there is an appeal pending before the division bench against the order of the learned arbitrator passed in section 17. But that is irrelevant to the extension of this mandate. That is the reason. That is the only submission they made yesterday. And my lord, I've effected service also. Shall file that.
We'll pass it over. Just safe.
I can give them a call going ahead.
Yes.
Just pass.
Pass over.
I'm for the petitioner, Your Lordship. This is an application under section 29A for the extension of the mandate of the arbitral tribunal. The other side is here. I don't think, Your Lordship, they'll give any objection because the arguments have been concluded. It's only for the passing of the award. Your Lordship, kindly sees the last minutes. Page 30, page 56, Your Lordship.
Yes. Just give me the date. When was the arbitrator appointed?
So the learned arbitrator was appointed. Your Lordship, ये लिखे नहीं है, okay? Sometime, Your Lordship, in 2020, the date exactly, Your Lordship, we
The first sitting was held in January 2019.
One petition, you don't read it.
Lordship, kindly.
Petitioner invoked the arbitration clause, para 4, page 3.
Yes, Your Lordship, that is the commencement of the arbitration.
So that's what I'm asking. When
Yes,
was
sir.
he appointed? Did you get an extension, 6 month extension?
Yes,
before the arbitrator?
2 extension we have got. Your Lordship, kindly take page 53 and 54. 53 and thereafter 54, 1 year from 20th November 2024.
One is 53, other is?
53 and 54, Your Lordship. 54, 20th November, 1 year from, Your Lordship, the date of communication, we have communicated immediately. So 20th November 2024. The last minutes, Your Lordship, was 27th October.
The present application. The petitioner preferred the present petition under section 29A of the Arbitration Conciliation Acts, seeking extension of time for conclusion of arbitral proceedings and for publication of the arbitral award. The petitioner invoked the arbitration clause, pursuant to which the respondent, wide letter dated 5/11/2018 appointed the arbitrator, the sole arbitrator, full stop. The sole arbitrator, by his letter dated 7/12/2018, had consented to the arbitration proceedings. Full stop. The proceedings before the arbitrator were completed on 22/5/2021. Full stop. The pleadings before the arbitrator were completed on 22/5/2021. Full stop. Thereafter, this court, by order dated 17/5/2024 and 20/11/2024, extended the mandate of the arbitral tribunal by 6 months and 1 year respectively. Full stop. The recording of the evidence and final arguments have been concluded, and the pronouncement and only the pronouncement of the award remains. Full stop. In these circumstances, the petitioner is seeking further extension of 6 months for the mandate of the arbitral tribunal to enable the tribunal to publish the award. Full stop. Upon consideration and submission and the material placed on record, this court is satisfied that there has been no undue or unwarranted delay on the part of the arbitral tribunal in conducting the proceedings. Full stop. Accordingly, the mandate of the tribunal is hereby extended further for a period of, you need 6 months to publish award.
3 months would be sufficient, but Your Lordship, due to his age, Your Lordship, if you can 4 months, Your Lordship, at least. I think 3 months, within 3 months, Your Lordship, we can deliver. Everything has been completed, written notes has been given.
Further for a period of
3 months, Your Lordship.
3 months. Just उसमें एक line पहले लिख लेना. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. With the aforesaid observation, the present petition is disposed of.
Your Lordship will kindly record, my lord, since no affidavit is being filed, my lord, the allegations are.
29A, what allegation? There's no allegation in 29A.
My lord, there are the
Not in this application.
29 inches देंगे.
This is simple application or extension of time, sir.
I'm grateful.
grateful.
Yeah, please, Your Lordship.
But I'm late. Sir Ratul Das Millard, who is joining virtually.
Well, I'm appearing. Well, this is one
Yes.
of case where I am opposing the 29A application on account of the petitioner's delay and no sufficient cause being indicated. That I have no issue with regard to the manner in which the arbitral tribunal had conducted itself during the entire proceedings. But my lord, on 6th of January 2025, there was a direction for us to appear and thereafter final arguments to be concluded in the proceedings. The tribunal's mandate expired on 23rd of February 2025, but no steps have been taken. Alert, since this is time bound, even the claimant is required to take steps appropriately, my lord. This is my submission.
May I just indicate, may I kindly have the minutes of the meeting which I have annexed at page 40 minutes, which are dated 12th of January. So on this day, my evidence got completed and they were directed to file.
Mr. Berry, page 40 is the order of 2nd of September 2024.
Page 40, then in that case, these are two petition minutes, AP 855 and 866. 855, I believe, has not been listed today because there are two different.
856.
This is 856. All right, minutes. Let me just take it out. The second petition. Eventually, the minutes are the same. So 6th of January minutes.
It is at page 41, my lord. 41 of
Page
my lord.
41. Yes, minutes. I'm so sorry. So page 41 is the minutes of meeting, wherein the arbitrator that day the evidence of both the parties got completed and the matter was fixed for final argument. Thereafter, because there are two different matters going on before the same arbitrator, the parties are the same, only the projects are different. So eventually, as per the directions of the arbitrator, the evidence has to be treated separately for both the matters. And once the evidence in one matter gets completed, the evidence in the second matter got started. So eventually, in one of the matter, the evidence is complete. The matter is has to be taken up for final arguments. But subsequently, after 6th of January, the evidence had to be taken up for the claimant in the other matter. So in that matter, the evidence got completed on 12th of January. The respondent
Your
was
voice
directed
is,
to file.
Mr. Perry, your voice is not clear. I'm not able to follow you. Can you just slow down?
Please, look. I'm so sorry. I'm so
I'm
sorry.
really not able to follow you.
Please, look. So
Because your
let's,
connection is not good. There's an
please,
echo in
look.
your voice.
I'm so sorry. Then I'll request that I'll come down physically tomorrow. If Milad can have it physically tomorrow, I'll come down.
My lord, instead, may I indicate, may I be granted 2 days time to file a short affidavit only on the point of insufficient cause being shown, because the petition does not mention any cause, and I have two judgments to cite before my lord. My lord, I am not on the fact that he cannot be allowed to extend, but I am on the fact that there should be certain conditions put on him in terms of any further extension, my lord. This is the only point that I wish to place before my lord.
I'll just indicate that there is also a counterclaim in this matter. It is not about the claimant only who has to file a 29A. The other side can also file a 29. Earlier, there was a 29A filed. There was a direction given to the respondent to file the 29A, but eventually that 29A was treated as premature because at that point of time, the 6 months extension given mutually by the parties was yet to expire on 23rd of February 2025. So this is the order dated 2nd of September 2024. Thereafter, the mandate got expired on 23rd of February 2025. Eventually, there is also a counterclaim in this matter by the respondent. It is not the burden of the claimant only to file a 29A. Since I personally requested the other side that you are stationed locally, let it be filed by you. But later on, they said we won't be filing it. So just on the count that there is a delay in filing a 29A, it doesn't mean that the arbitration proceedings to suffer. That is my humble submission. In any case, Mills, I'll come down physically to satisfy Mills on this point. Mills grants me 1 day's time. I'll be there.
Monday. Keep it on Monday.
Much obliged, my lord.
Monday.
Tuesday, plus I have a matter at Bombay.
Tuesday.
My lord,
Much obliged.
my lord, OCD 3, which was passed over, my lord, I had a word with the respondent. He said that he will not be appearing today. My lord, a direction may be passed so that he can, last chance may be given to the defendant for appearance, my lord. Was there, this is the third time, my lord, they are not appearing. I've already served them a notice.
Just serve them.
Yes, my lord, I've served them a notice.
We'll pass an order.
I shall
Indicate.
later, my
Affidavit of service taken on record. Where's the affidavit of service, madam?
I've served them. My clerk will hand over the affidavit of service within the course of the day today. I've served them, my lord.
Where's the affidavit of service?
I shall file the affidavit of service.
Look at the last order. You have been asked to file affidavit of service.
My lord, on the last order, my lord,
Effect service on the respondent.
I shall prepare
So,
the
yeah.
affidavit.
Not today. Keep it. Monday we'll keep it.
My lord,
Monday.
my lord, item number 2, my learned friend is here. If
Yes.
my lord kindly permits.
But first, I must, Milord, say I am extremely embarrassed, Milord, because we did not know, as advocates, we did not know.
My lord, I have nothing against my learned friend.
And
We
when I
all
came to
work
know,
for
Milord, I have immediately written up my
instruction.
advocate on record to write an email to Lordship. Will kindly have a look at this, Milord, to the client, Milord, saying that the instructions which they had given was incorrect, and we found it from our learned friend. We have told him to give us the current status of all the assets.
Now, what is the status?
My lord, this email has not been responded.
So, my lord, I had spoken to Mr. Guha. I told him, my lord, that in this situation, it would be extremely unfair from my side to make any comment with respect to any of the assets. So, your lordship, my lord, if your lordship so deems fit, your lordship can ask this particular award debtor to produce, my lord, disclose his assets on affidavit.
Why
at the
should I
quickest
get
time
into that?
possible.
I'll just
My
restrain
lord,
him.
that very well, my lord.
Because, my lord, the risk which we are running here, my lord, is that if he has sold the properties to third parties and if there is orders of injunction on that, unfortunately, the innocent third party purchasers will be embroiled in trouble, my lord, from orders passed by the highest forum.
The problem with this creates a big problem for us.
But it's extremely embarrassed for me. I'm extremely embarrassed, my lord.
And then you're not even able to get instructions.
My lord, I've written to him.
And
And
writing doesn't help, sir.
my lord, we
You
have
have to get
spoken.
the
We have spoken
instruction.
as well, my lord. And he has responded over WhatsApp that he is traveling and he is going to give instruction after a week. This is the kind of
This is the way he treats the court. Then I should send him to jail.
my lord, I really do not have any more control over it, my lord. He has first, my lord, put us into great embarrassment before your lordship, which is, my lord, something which I have never faced, my lord, till now. And this is the conduct which I am tackling before your lordship.
Who's
But
the
I am
advocate on
extremely
record? Who's the advocate on record?
Lord, Mr. He instructed me and I made my.
What kind of instructions are you giving? How can your client take the court for a ride like this? Where's your client? Can't he join virtually and give you instruction? You should not represent such kind of clients. You're all part of the same gang. At least you're first officer of the court. Be fair to the court. You get these kind of orders passed on wrong submissions. Your sorry is not going to help, sir. It is not helping. And then you just stand here with a poker face. This matter is taken up on mentioning. Full stop. This court, by order dated 18/11/2025, had restrained. What's the sign? Kalwala. Had restrained I'll just sign it. Had restrained the respondent from alienating, disposing or creating any third party right or interest in respect of the property known as Shrikunj, inverted comma mein, Shrikunj apartment, being flat number B101 at measuring 1408 square feet built up area on the first floor of tower B, situated outside Jasusar Gate, behind Kothari Medical Hospital, Bikaner. Full stop. Learned counsel for the respondent submits that prior to passing of the order, third party rights have already been created in respect of the aforesaid property. He further submits that, owing to lack of instruction at the relevant time, he inadvertently stated that before this court that the property that no third party rights have been created. Full stop. Today also he appears and states that his client is not giving any instructions and has refused to cooperate with the council. Full stop. He states that he is unable to give any instructions as far as the status of the properties are concerned. Full stop. Shall we just restrain them the entire property, or you want them?
My lord, because
Or you want him
before
to
filing, we
Yes.
have carried out the search. That till that point of time, we found that the other properties, that is 13B Ramoy Road, that is still in his name, his share. So, my lord, kindly restrain him from creating any further right over those properties.
Milord, we got information with respect to two properties, Milord. The first property at Bikaner, he has informed us that he has sold it in sometime in 2021, 2022. There is a property in Bhawanipur, and Milord, he has told us that that is, Milord, encumbered with some bank. These are the only two instructions I have got, but since I didn't get it in writing, Milord, as we had sought for, I have not mentioned it before your lordship.
Where
till
is
now.
that supplementary affidavit?
Milord, that is page 216 of volume 2. If my learned friend is referring to that property, Milord, it may not suffice the purpose. That Bhawanipur একটা property আছে। But
Because
এখানে
this
এখানে-
property number 2, 3, and 4 are the 3 floors of Bhawanipur property only.
Milord, then he has embroiled it with some bank, Milord.
You tell me what you
My
want.
lord, in that event, if that is the submission, I still means I don't want to let my friend in again be an embarrassing situation, because that is not on in any
Given
writing.
it to me in writing, but
My
he
lord,
has told my advocate on record over phone.
in any event, this list is pending. Let the respondent file his affidavit of assets and bring on record what all are the properties, because we don't trust him, and there is no point of letting my learned friend again fall into the same embarrassment.
I told this to Mr. Guha, Milord, even last evening, that he must be, his assets must come before the court on an affidavit signed by him.
This is a peculiar situation. Otherwise, generally, we don't go this far in a post-award section 9. We simply just get an order of injunction to protect.
As it appears, Milord, these properties were already injuncted. So he has dealt with these properties during order of injunction.
How could you do that?
Because Milord, there was a section 17. We were not appearing at that time,
That's
but there
right.
was a section 17 application.
Right.
During the section 17 application, it was passed on consent. I've checked the records. And he has sold these properties either prior to that or in course of that section 17 order. And these properties were disclosed by my learned friend's client. So he should have come up before the tribunal and said that I have dealt with these properties, which he didn't. Don't protect this client. What will you
ব্যাংক
protect?
যদি ব্যাংকের কাছে মর্টগেজ করে তো সেটা অনলাইন দেখতে পাবে, চার্জ ক্রিয়েট করে।
Bhawanipur property.
হ্যাঁ, বুঝে গেছি, তুই বলছিস যখন তো ডেফিনেটলি।
At least we will restrain them.
Yes, my lord, kindly restrain them, and my lord, let the kindly set an example, my lord. Let him file an affidavit of assets, because they should not take the court for a ride, my lord. I have nothing against my learned friend, but
See,
this
if he has
respondent,
sold it, he has done something against the order of the tribunal. You have your remedies.
my lord,
You
today
can
I don't have a
exercise that.
remedy. Reason being, the tribunal has become functus officio.
That's all right. But any contempt, you can always
Yes,
file
yes,
it.
yes. Contempt I can very well brought
Always
it,
file
but
a
my lord,
contempt.
kindly pass an order of restraint, and kindly, my lord, pass an order for affidavit of assets. Let him file, my lord.
Affidavit of asset, I don't think so. This
Very well, my lord. Kindly pass.
Lord,
an
if I'm restraining, then I'm not.
May I make this submission, Milord? I'm just trying to assist your lordship, Milord. If this 17 lakh is, today we are trying to secure this money. And if, Milord, I have also been told there is some terms of settlement, talks of settlement. If it fails, my learned friend is going to come up before your lordship for execution. The first thing is affidavit of assets.
Correct.
So, Milord, your lordship is actually preponing, Milord, this stage now. That will assist my learned friend, because the conduct of the respondent over here is not absolutely deplorable. So even if your lordship asks him to,
Affidavit of asset in this.
Milord, assets in terms of the form in the code of civil procedure, he will not be in a situation to, Milord, avoid that.
Let him file a execution, then affidavit of asset will come.
Because, Milord, we have Rahul S. Shah's judgment, your lordship is aware, Milord. There any kind of money, any money debt, Milord, the first thing which the court can do is ask the person to file his affidavit.
So that is where the execution proceeding comes in.
Milord, that is passed in all money debts in general, even in suits. This is my submission before your lordship.
We'll restrain him. We'll see whatever.
Very well, my lord.
Calico.
My lord, in that event, kindly keep the section 9 pending for some time, because in case something happens, we might have to apprise the court.
Should I keep the section 9 pending? For what? You can always come back. Learned counsel for the petitioner states that the learned tribunal, while its order dated 10/2/2024, had restrained the respondent from creating any third-party interest over the properties as mentioned in para 51 of section 17 application, read with serial number 1, 2, 3, 4 of paragraph 4 of the supplementary affidavit dated 22/1/2024, forming part of annexure C and D of the present petition. Full stop. Learned counsel for the petitioner further states that he shall be satisfied if the respondent is restrained from creating any third party he shall be satisfied if the respondent is restrained from creating any third party right or interest in respect of the property as mentioned in para 51 of the section 17 application, read with serial number 1, 2, 3, 4 in para number 4 of the supplementary affidavit dated 22nd January 2024, being annexure C and D. Full stop. In view of the statements made by the learned counsel for the respondent, the order dated 18/11/2025 stands modified to the extent that the respondent is hereby restrained from alienating, disposing of, or creating any third-party right or interest in property number 2.
Kindly make it 2, 3, and 4. Why I
3
say so?
and 4.
In case if one of the property is mortgaged, I
3
can
and 4.
exercise my right over the other.
Property number 2, 3, and 4, which shall stand furnished as security to the awarded amount. Full stop. It is clarified that the restraint earlier imposed on the property known as Shri Kunj, so and so apartment वगैरह, is hereby vacated and the said property is released from the operation of the order dated 18/11/2025.
I'm so glad.
Accordingly, the order dated 18/11/2025 is hereby is modified to the aforesaid extent. Full stop. The registry shall make necessary notings in the order dated 18/11/2025 to reflect the modification. वो तो जाएगा आज को इसको मॉडिफाई करके ये आ जाएगा, ये डिस्पोज्ड ऑफ.
এই এক্সিকিউশন দেখানো আমরাও তো একটা লেভেল দাঁড়ি বাড়ি টানাটানি. I'm so grateful.
फाइल में डालो तो वो करो, अपलोड कराओ ताकि.
I apologize, but I'm fixing this.
Yes.
Six, my lord, I am appearing on behalf of the
I appear for the
respondents.
petition, my lord.
My lord, this is a section 9 application.
Where's your affidavit? See the order. You're supposed to file your affidavits.
Communicated to them at least
Detailed
5
order has been passed
My lord, the
by the
advocate
predecessor bench. You don't see orders and all.
the advocate record hasn't forwarded, only forwarded me the soft copy, my lord. I haven't gone through
What
the
is
order.
this? Advocate on record. You are appearing in the matter.
Yes, I'm appearing, my lord. I was instructed to appear, my lord.
Then you have not seen the last order.
He also appeared, my lord, on the occasion prior to the last occasion.
Just one moment, my lord.
He order touch it, no, देखिए.
The first line itself of 22nd September order. Just see the first line.
Yes, my lord.
You have the order.
Learned
That is
counsel
what
for
I
the
was seeking, my
respondent.
lord. I would seek
File-
time to file this affidavit, my lord. That is what was placing, my lord. Yes, there was a direction, my lord. My lord, what I say, my lord, the respondent, my lord, number 2 and 4, my lord, their brother and son, my lord, are going to get married on 30th. That is why I was seeking some time, my lord.
You have already been granted time, sir.
For the seek that extension, my lord. May that be extended, but may that be extended, my lord.
Learned counsel for
My
the
lord, just one indulgence, your lordship. They have not complied the order dated 22nd September 2025. Kindly turns to page 2, my lord.
Yes.
My lord, they were directed, my lord, to furnish the details of the accounts for the last 6 months, including the withdrawals which has been made from the company. We have written them notices also regarding the compliances. They have just kept quiet on this issue. Despite not filing affidavits, they have also not
That's
complied
some
with
time, my lord. I'll comply with this portion, my lord.
intentionally, my lord.
Learned counsel for the respondent seeks and is granted further time of 2 weeks to file his affidavit
In opposition.
in opposition as directed by this court by its order dated 22nd September 2025. Full stop. Learned counsel for the respondent further undertakes to comply with the directions given in the order dated 22nd September 2025 and shall be furnishing the details of withdrawals that has been made from the bank for the purposes of running the company. You furnish those details that shall be furnished to the.
Kindly grants me 3 weeks time, I'll file the affidavit and I'll furnish the details, my lord. Because the marriage is on 30th of
वो काट दो. Learned counsel for the respondent further undertakes to comply with all the directions given by this court by its order dated 22nd September 2025. List after 4 weeks.
Your lordship is giving them only 2 weeks time. After 2 weeks, it can be listed.
3 weeks.
my lord, the marriage is, my lord, the
How is related to marriage? You file your affidavit.
client's son, and saying, my lord, the respondent number 2 and 4.
They choose not to
3 weeks,
appear
my
for
lord.
6 times, my lord, and then they come and say marriage,
The
marriage, marriage.
I'm praying for 1 more week. No, 3 weeks. I'm only praying for 3 weeks.
You have already taken a lot of time. I'm not going to give you any more time. And marriage doesn't mean that the court is going to wait.
No, my lord, not, I'm not saying that. My
Your
lord,
lordship kindly remembers on
my lord, only
6th
praying.
occasion matter was taken up. He didn't appear intentionally, despite being on notice.
Your-
Now when he comes, he
your-
takes
Your
time.
conduct doesn't inspire this court at all after 3 weeks.
Grateful, my lord.
Lordship, I'm appearing for the petitioner. This is my Section 9 application appearing for the first time. Lordship, it has been served by on the respondents. The affidavit service is already filed, Lordship.
You are appearing for the respondent.
I appear for the respondent, my lord.
Lordship, this is a chart that I have prepared for Lordship's assistance. Lordship, this arises from a loan agreement, Lordship, which is at page 17. Lordship, the arbitration and the jurisdiction clause is at page 28, Lordship. It is a clause 8.
Page?
Lordship, page 8. It starts from page 8. The relevant clause is at page 29, 8.4, where the seat of arbitration is at Kolkata. Clause 8.4, the last line.
Yes.
And Lordship, the 8.8 gives the jurisdiction subject to the foregoing. The courts of Kolkata, West Bengal, or such place as may be solely decided by the lender shall have exclusive jurisdiction in respect of the matters. It's in the same page, page 29, Lordship. Lordship, a loan was given to the respondent to the tune of rupees 25 lakhs. It had to be repaid in 48 months. Lordship, they had started defaulting from 3rd April 2025. That is on their 6th installment. Lordship, we have given a loan recall notice. Thereafter, we had started with the appointment of the arbitrator and the arbitration proceeding, but there was an objection because there was a sole arbitrator appointed by us. So the arbitrator has reclused. So there is no arbitration at this point, Lordship. Lordship, the claim that we have made in this petition is to the tune of rupees 26 lakhs and odd after termination. So Lordship, either they secured the amount for us or I have prayed for an injunction on the bank account. The details are given.
My lord, this possibly doesn't come within my lord's jurisdiction because my lord, if my lord kindly sees the cost title, my lord L&T Finance Limited, my lord, kindly sees the address, and my lord, then my lord, I can show that the agreement has been signed in Chennai, digitally signed in Chennai, the loan agreement itself.
You have consented to the seat of arbitration to Calcutta.
My lord, it is Calcutta, but not the original jurisdiction of this court, my lord.
Lordship, I have judgments to that effect, that Kolkata and Principal Civil Court 21E means Calcutta High Court.
My lord, if I may have a...
I'll just refer the...
Give a copy.
Lordship, I'll just... Do we have another copy? Okay. No. I'll just, Lordship, refer to the paragraphs and share a copy. Lordship, here similar point was taken on the point of maintainability of the application on the ground that this court does not have territorial jurisdiction. Lordship, thereafter, the advocates have given their arguments and the conclusion of the court comes at from page para 14 onwards. The exclusive jurisdiction and venue arguments are being separately dealt with. And the exclusive jurisdiction, Lordship, City of Kolkata, similar kind of clause. The respondent's objection that the clause is vague and lacks necessary particulars to only mean the Calcutta High Court to the exclusion of all other courts in the city of Kolkata merits consideration. It is correct that many of such clauses suffer from a generalized brushstroke to broadly include any court within a given territorial boundary. The vagueness particularly comes to the fore when there are multiple courts in a city like Kolkata, and particularly after the Commercial Courts Act 2015, under which at least 2 courts in Kolkata contemplated and a total of 4 courts within the extended territorial boundaries of the city. As such, as this court finds generalized clauses to be misleading and insufficient for the purpose of designated a court, the jurisdiction and application under section 9 must be placed in context. Thereafter, Lordship, the commercial courts have been defined, and then there is the venue of the arbitration is also taken into record, and then in para 18, although for the purposes of the present matter, the factum of the cause of action have a reason within the jurisdiction of court, marks the territoriality issue in favor of the petitioner, and the seat of arbitration becomes secondary and alternative to the first argument, which is to dwell briefly on the seat point. And therefore, thereafter, para 19, it should be pointed out that the choice of the court where any application under part 1 of the 96 Act may be filed is governed by section 21E clause 1 in conjunction with section 42 of the Act. Section 21E1 lays down the tier of the court taken within the territorial and the jurisdiction parameters for making it competent to decide the question raised in application. And thereafter, Lordship, para 20, the last part, it must be borne, Lordship, in the last portion, it must be borne in mind.
Must also. Kindly do not.
It must also be borne in mind that the parties have consented to the jurisdictional clause, which is clause 18K, as well as the seat of arbitration as provided as 18.1. Both the clauses point to Kolkata. The objection is to the interpretation of the outer limits of the city of Kolkata and whether the clause can be stretched to include the greater city of Kolkata. Section 21E1 of the 96 Act designates the principal civil court of original jurisdiction in a district, including the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the question forming the subject matter of the arbitration for the purpose of application in matters of domestic arbitration under Part 1 of the Act. The discussion would have been different had the issue in the present case been one where the petitioner would be left only to rely on the seat or venue of arbitration without the assistance of the exclusive jurisdiction clause also pointing to Kolkata. Section 21E1 as well as the effects of the commercial court have fortunately come to the aid of the petitioner to anchor the proceedings to the High Court at Kolkata as the only available court to decide the matter. The presumption of the contract having been signed with the petitioner situated with the ordinary original civil jurisdiction also tilts in the favor of the petitioner. But the primary point is the venue and the jurisdiction being pointed as Kolkata.
Yes.
My lord, if my learned friend would have given me a copy, my lord, I would have.
I did not know you were appearing.
My lord, kindly comes to paragraph 13, my lord, of this judgment. Paragraph 13, my lord.
Yes.
With reference to the above documents, although the address of the petitioner has been mentioned as the Salt Lake address in all communications, documents cannot be taken as unimpeachable evidence of the transactions having taken place wholly outside the jurisdiction of this court, or that not even a single transaction was carried out at or from the petitioner's Kiran Shankar Roy office. Further, although the respondent has denied the averment of the agreement having been signed at the petitioner's office at Kiran Shankar Roy Road, there is no supporting document to specifically corroborate the denial. Agreement states that one of the petitioner's offices are located at Kiran Shankar Roy Road and the parties are shown to have signed the agreement at Kolkata. The document is buttressed by the pleading at paragraph 3. So, my lord, in this case, the document would show that the agreement was signed at Kolkata. In this case, my lord, kindly comes to the last page of the agreement, my lord, at page 38. There's a digital signature, my lord. And my lord, my instructions are, and I can put in a short affidavit to this effect. My instructions are that everything happened digitally and nothing was done in an office in Kolkata. Those are the instructions that I have received. So, my lord, kindly let me put in a short affidavit to that effect. Page 38, my lord, kindly sees the signature, my lord. It is a digital signature. Location is Chennai.
Yes.
And apart from that, my lord, I'm citing the Sanghi Industries judgment, my lord. I'm also citing the Order 38 Rule 5 principles, my lord. In this case, my lord, there are just bare averments that I am going to dispose of all of my properties, or I may dispose of all of my properties. That is it.
Lordship,
There
they
is no.
paid from April 2025.
And my lord, may I act a second? I'm just. And there is also a settlement letter that I have sent to my learned friends. This has been sent in November. So I can place all of that before my lordship. And my lord kindly gives me some time to put in an affidavit. I think I will be able to satisfy your lordship on this point. After that, my lord kindly considers the issue.
My apprehension lies they have not paid from April 2025. And since then, no payment have been done. A termination notice has gone. We had started arbitration. They had objected to that. Lordship, and the point that they are stating that Order 38 Rule 5, Lordship, Section 9, it is a arbitration is in itself an individual code, and it's clear that if I have a subject matter today, if I go for an arbitration and they do not secure my money, even if I get an award, it will not be repaid. So therefore, that is, I am not asking for an injunction. They can secure this amount, keep it in their bank account aside. I am not taking it from them. Keep it aside. Lordship can thereafter give that injunction for 3 months and we can go for an arbitration. Let it be valid only for 3 months. Let me try my luck before
my lord,
the arbitration.
I'll tell you what the problem is, my lord. From what little communications that I have received, I'm not in a position to place that before my lordship today. From whatever little communications I have received
from your client.
I understand that he he doesn't have enough assets to secure them. But I will take instructions. Kindly keeps it tomorrow or day after. I can come back with instructions. And my lord, I am pressing for a dismissal of this petition on the ground of cause of action and order 38 rule 5. So
of action, sir. The agreement itself is quite clear. We can deal with that.
very well, my lord. Give me one more opportunity. Let me come back with instructions, my lord. Because if my client is not in a position to secure the amount as on date, my lord, let me understand also from him how he can possibly assist your lordship. Let me do that.
Monday,
Monday, lordship.
not today. Keep it for Monday.
हाँ, AP 185 or 22?
8.
I pray for God fast, but not be appearing in the back.
So let me hear him.
Yes.
Well, I address your lordship first on the maintainability issue which my learned friend has raised.
Yes.
First, my lord, I do not know whether they are pressing the 42 point or not. 42 point, there is a clear answer. If your lordship sees section 42, 42 does not apply to appeals. It is a provision which is only applying to application, and the Supreme Court is very clear on that. Kindly see section 42. তুমি কি মেইনটেনেন্সটা বলতে চাও তাহলে বলে দাও।
Yes, yes, yes.
You had approached the city civil court, right? Commercial court.
Commercial court against an earlier order.
Yes.
That is an earlier order, which I had gone to the commercial court.
So you are forum shopping now.
Not to question, kindly have a look at the jurisdiction clause here in the agreement.
Yes.
Agreement governs us. Kindly have a look at.
You were showing section 42.
Yes, section 42. Kindly see, my lord, jurisdiction notwithstanding anything contained elsewhere in this part or in any other law for the time being in force, where with respect to an arbitration agreement, any application has been made under part 1. Number 1. Made in a court, that court alone shall have jurisdiction over the arbitral proceeding, and all subsequent applications arising out of the agreement and the arbitral proceeding shall be made in that court and in no other court. Now kindly have a look at, my lord, section 37. 37 is appealable orders. 37(1), notwithstanding anything contained in the law for time being in force, an appeal shall lie from the following orders and from no others to the court authorized by law to hear appeals from original decree of the court passing the order. Namely, I am coming under, my lord, subsection 2. An appeal shall also lie to a court from the order of the arbitral tribunal. 2b, granting or refusing to grant an interim measure under section 17. So if it is a 37 appeal, it will lie to a court from the order of the arbitral tribunal, court as in section 21e court. Here, it is not an application. 37 is excluded from 42. Now, this your lordship will kindly get a judgment.
Let me just indicate one thing, my lord. I will be permitted to show judgments, my lord, after Wednesday.
2007 one is
467.
paragraph Yes.
36 or 34.
Kindly come to, my lord, paragraph 21 first. An appeal in terms of subsection 2 of section 37 is a statutory appeal. It may be true that subsection 3 of section 37 debars the second appeal from an appellate order under subsection 1 and 2, but having regard to section 5 of the 96 Acts, provisions for section appeal may be held to be superfluous. Then kindly comes to, my lord, 23. In this case, it is not necessary for us to go into the question as to whether subsection 3 of 37 would debar an appeal from an appellate court order under subsection 2 of section 37 thereof. The consequences of the statutory embargo would ensue, but then the question will have to be considered as and when occasion arises therefore. Subsection 2 of section 37 prescribes for an appeal to a court. We do not see any reason as to why, having regard to its plain language, the definition of court shall not be put into service. It may be true that the interpretation clause provides for unless the context otherwise requires. If the application of the interpretation clause contained in section 2 of the 1996 Act shall lead to anomalous and absurd results, one may not stick to the definition, but we do not think that such a case has been made out. So ordinarily 2(1)(e) is to the governing section for 37. Then, my lord, 24. Courts, my lord, section 42. Section 42, to which our attention is drawn by the Learned Council, has no application. Said provision reads thus. Then, my lord, 26. Section 42 of the 1996 Act refers to applications and not to appeals. And 24 says it has no application. Then, my lord, kindly come to last paragraph at 34. There exists a distinction between an appeal and an application. Whereas section 31(4) of the 40 Act or 42 of the 96 Act provides for an application, subsection 2 of section 37 of the 96 Act.
What are you reading? Sorry.
I'm sorry, 34. Para 34, last. Page 475. There exists, got it? There exists a distinction between an appeal and an application, whereas 31(4) of the 40 Act or 42 of the 96 Act provides for an application. Subsection 2 of section 37 of the 96 Act provides for statutory appeal. A forum of an appellate court must be determined with reference to the definition thereof contained in the 1996 Act. So this is the first point. We have to go back to section 2(1)(e) definition for the purpose of court. Now, if I go back to the section 2(1)(e) definition, your lordship will have to look into the agreement also if it contains a jurisdiction clause. Then, in the definition of court, that will gain primacy. That is the principle. Now, your lordship will kindly come to the jurisdiction clause in the agreement. Your lordship takes volume 1, page 52. So, my lord, my going to the Rajarhat Commercial Court and drawing the analogy of section 42 is first out, my lord, here. Now, my lord, whether I have come to the right court.
Page 52, volume 1. 50, which page?
But 52, page 50. Stay petition, volume 1. Clause to 52 there.
52, yeah.
pleading
না pleading না আমি agreement
supplementary
I'm sorry it's a supplementary affidavit volume 1 really sorry. This is not part of the agreement, clause 12.1. Dispute settlement and jurisdiction. 12.1, my lord, is the arbitration clause. I'm not placing the entirety. Kindly see last 3 lines of that clause. The arbitrators will have summary powers, will be entitled to set up their own procedure, and the arbitrators shall have to give interim award and no direction. Next, the place of arbitration shall be at Kolkata, and language in English. Then 12.3. In the event that the parties cannot resolve or settle a dispute through any of the means described above, the courts having territorial jurisdiction over the said premises and High Court at Kolkata shall have jurisdiction to entertain and determine all actions, suits and proceedings arising out of these presents between the parties hereto. So, my lord, what is the effect of this arbitration clause read with the jurisdiction clause? This place of arbitration at Kolkata read with the jurisdiction conferred also on the High Court at Calcutta implies that the seat of
Mr. Sen, then why didn't you file your first, application here?
No.
Why did you choose to go before the commercial court at Rajarhat? Today you're not able to get any relief. That's why you come here.
I would say, well, that was a wrong forum.
That was the wrong forum.
Yes.
All right.
That was a wrong forum.
All right.
One of the, in fact, it was one of the forum, your lordship will see the courts having territorial jurisdiction of the said premises and the High Court at Kolkata. So, my lord, here, my lord, Kolkata is the chosen seat of the arbitration. And if it is the chosen seat of the arbitration, in terms of the Bolko judgment, Indus judgment, this is the court which will be having supervisory jurisdiction over the arbitration process. And the judgments go to this extent that in case of an arbitration proceeding, irrespective of whether cause of action arose here or not, if the venue or the seat is at a particular place, that is the place which will be having supervisory jurisdiction. Unlike in case of a jurisdiction for a suit, where...
See, Mr. Sen, if you would have argued all this, if you would have not gone to the commercial court at Rajarhat, I would have understood. Today you have chosen, and now you are saying, oh, that was a wrong call. I made a mistake. I shouldn't have filed it there. I should have come here.
That is as per the
you
clause.
subjugate yourself to a court, then you stick to that court. Don't come here. That is what section 42 says. You are confining it only to applications. I would say even this is actually arising out of an application only. It's an order which has been passed under section 17, which you had tried, you failed, you have come here.
It is not a
You have tried, you failed, you have come here. That's why you are here.
But I tried, I could not understand. I have not
You have not been able to get a favorable order. And that
before
is
with the arbitrator.
before the arbitrator.
Yes.
Your money was secured. You went there on the...
I need to go into the facts, my lord. Otherwise, my lord, your lordship is, my lord, taking a very bird's eye view of the matter. My lord, your lordship...
Give the facts. I'm ready to hear the facts.
Yes, my lord, then kindly see, my lord, kindly, my lord, your lordship hears the facts. The principles of law has to be absolutely observed, my lord. Without principle of law, and it is a very simple issue, when a security can be granted, when attachment can be granted, and when receiver can be granted. This hinges only on this issue. My lord, kindly consider, my lord, 2 orders passed by the tribunal. My lord, this is a case where the tribunal initially felt that it is not a case for attachment. Then, when an application for interim award comes also, the tribunal feels that no interim award can be passed, but directs that same amount which in respect of which no attachment was passed, that has to be secured. Very well understood up to this. Then a further application comes from their side, but I am just giving your lordship, but I will take your lordship to the order. Otherwise, my lord, where the legal flaw has occurred, your lordship will not be able to appreciate that. Now, my lord, after this security order is passed, interim award is declined, security order is passed, they file an application for appointment of receiver.
Yes.
And
Yes.
So 24th April is the second order by which receiver is appointed over all the unsold flats and the car parking spaces in the building.
Yes.
Now, kindly see what is the effect.
Yes.
Firstly, my lord, what is the purpose of the security? Claim, there is a claim which the arbitrator feels if the arbitration goes on, unless there is some kind of security, he will not be protected. Because everything is in the possession of the developer. So the security is granted for 11 crores. Then the portions which are in the possession of the receiver is taken away from the respondent and put in the hands of a receiver. So this becomes a double security. 11 crores you are already secured. Now you are secured in terms of immovable property. Now also at this, thereafter a further subsequent event occurs. I am directed to hand over possession of 4 flats with car parking space and execute and register an agreement in their favor, conferring title upon them so that they can deal with those 4 flats. This agreement is executed by the receiver on my behalf, on their allegation that I have not done it. But the execution is done, registration is done. So what is the second additional fact? You are in possession as owner of 4 flats and car parking spaces in the building. And the value of that 4 flats and car parking spaces, you have ascertained it at 6.61 crores. Now, so therefore now comes my application before the tribunal. This I say that he is now completely secured because receiver is in possession. Whatever sale takes place of unsold areas in the flat and the car parking spaces, everything will be collected by the receiver. He is in possession as owner of 4 flats and 4 units. That is also 6.63 crores. He has already said and admitted, I will show that he has received 3.75 crores after the order. And that is in his statement of claim. So anyway, this 11 crores is not necessary. There is no question of any security for 11 crores because you have security much more than 11 crores. This is the simple purpose of the application along with the other reliefs. Other reliefs relating to receiver having taken possession of car parking spaces belonging to third parties. Then the supplementary agreement which has been executed, appropriate deduction must be given in the joint venture agreement. That can still wait. But this is the basic principle that your unsecured claim firstly became a secured claim. There is no provision in law for a security to be furnished under Order 38 Rule 5 in respect of an absolutely unsecured claim. Nevertheless, now your claim is becoming secured through the receiver's possession. That is also ignored. So, my lord, where is the provision of law going? Lord, kindly come to the order. Once, my lord, your lordship will kindly come to the order, my lord. No, first I'll show your lordship the order by which and the view of the learned arbitrator why the attachment is declined. Kindly come to the stay petition volume 2. Yes. Kindly come to page 166.
Industry 24 package.
Yes.
Kindly see, my lord, regarding the claimant's second application filed under section 17 for attachment before judgment and other interlocutory reliefs. This is being considered. Kindly, I'm not placing the entire, kindly come to the relevant portion page 166. Well, 167, second paragraph, your lordship will see. Thus it appears that accounting is necessary to trace out the exact claim of the claimant attributable to its share of 40% in the sale consideration. Such accounting.
Where are you reading? Sorry, where are you reading?
167. Second paragraph starts with thus it appears.
Thus it appears.
That accounting is necessary to trace out the exact claim of the claimant attributable to its share of 40% in the sale consideration. Such accounting without evidence is not possible at this stage. So it cannot be held at this stage that the claimant has monetary claim of an ascertained sum and the respondent has admitted the claimant's claim in this regard. Such conclusion cannot be readily drawn without further investigation. And as the respondent claims that the statement sheet enclosed by the claimant to its pleading is not the statement prepared by the respondent. From the statement sheet annexed to the second application under section 17 of the Act, it appears that none of the pages of the said statement sheet excepting one page bears the stamp and signature and authentication by the respondent. However, it is rightly pointed out, Mr. Chaudhary, that those statement sheets were disclosed and relied upon by the respondent in affidavit filed before the learned commercial court in connection with an application taken out by the claimant under section 9 before the learned commercial court. As such, the statement of sheets cannot be ignored altogether at the interlocutory stage. In the absence of proper explanation from the side of the respondent as to why such statement sheets cannot be relied upon. Thus, though apparently some money is admittedly payable to the claimant on account of its share as per development agreement, such admission itself is not sufficient to pass an order of attachment in the manner as prayed for by the claimant. Passing of an order of attachment depends upon satisfaction of some other consideration. Let me now consider as to whether those conditions are satisfied here. Though some vague allegations are made by the claimant that respondent various creditors, they are permitted to dispose of flats and the ultimate award may be rated as the respondent no other asset. Even the name of the creditor and particulars giving the details have not been disclosed. On the basis of such evasive pleading, relief for attachment before the judgment cannot be allowed. For identical reasons, other reliefs cannot be allowed with the rider that prayer D will be dealt with by the tribunal. So this is their first application dealt with in this manner. No attachment because there is no admission, subject to investigation. This is the finding, absolutely correct. Now kindly come to their next application for interim award. That is at page 179. Kindly see regarding application under section 31 Act. The other prayers in the other section 17 are disposed of by continuing the arrangement which was prevailing regarding the sale. Now, this is 31. Kindly see the first line. Claimant has prayed for an interim award by relying upon the statement of accounts being Annexure E to the statement of claim. Annexure E is a specific statement on which they say in their statement of claim 11 crores is due. By referring to Annexure E, such and such contended as per own showing landowner's share in both residential and commercial areas 14 crores 73, admittedly a sum of which 373 has been paid by the respondent to the claimant. So 14 minus 3, 11, they were claiming 11 as an interim award. On this statement, they were claiming the attachment, which was declined.
Why are we getting into all this? Why don't we just deal with the maintainability? Let them argue the maintainability. You answer it. We decide the maintainability point, and then we go ahead.
No, but maintainability.
Going into the facts of the entire.
No, maintainability I will always satisfy. But the question is, your lordship will have to get into the merits of the order also.
We'll get into the merit of the matter once I see that it is maintainable.
Then, let me place my judgments on maintainability.
They are the ones who are
very well, but I don't mind anything. But my point is, I must get a forum to have my. But what is happening, I will tell your lordship. The matter is just going on prejudice.
No.
Unfortunately, yes, that's what is happening before the tribunal. That is what is happening.
If prejudice has to
No. Therefore, my lord, your lordship has put a very pertinent question. Why I did not go to the commercial court? I am sure I am being very frank, and I am telling your lordship
Yes.
I'm making a very frank concession and telling your lordship why I have not gone. My lord, I have firstly in law, I have two forums. Under the jurisdiction clause, I have two forums. Choice is on me. And why I have deviated from the choice exercise earlier. I'm very clear. It is the order and proceedings are being conducted by a retired Chief Justice. I would not prefer to have it tested through the commercial court. It is not, I feel that it is not a level playing field. And I will support my choice on the basis of the legal provision. If there was no choice of jurisdiction, as in the High Court is not included at the forum, I would have had no choice. But a choice is there to the litigant. The law provides the choice, but I have availed of that choice.
So once you avail of the choice there, and then you come here to the High Court.
29A also they filed there. They filed the section 9 there. They also have not chosen to come here.
Why will
They are still not chosen to come
here?
Now the 29A is coming here. But I will show that law provides me the remedy. I will show that law provides me the remedy.
Yes.
But I am sorry to say that it does not mean that once I have gone there, I will always have to go there.
So same, we will.
That is the
Yes, but I will show that.
Yes.
Well, I will.
Let us first deal with the maintainability.
Yes.
And then
I am not shying away from maintainability.
Well, I will have 4 points. Well, I'll address what my learned senior friend has said. Well, firstly,
let's not get into the merit of the matter.
I'm not getting into the merits. I'm strictly, my lord, on the maintainability, my lord.
You argue.
I totally agree, my lord, on the argument of section 42. It may not strictly apply to me, although, my lord, it has fallen from your lordship that, my lord, it will. Lord, even though, my lord, I will not argue on that point, I say, my lord, it is not even a question that section 42 will apply to an appeal or not. My lord, the scope of the act, my lord, says that, my lord, section 42 will apply for everything in part 1. That is the scheme, my lord, except section 8 and section 11. There is nothing, my lord, there are interpretations that there is nothing in section 42 strictly saying that it excludes the section 37. And my lord, there are a caten of judgments saying that section 8 and 11 are excluded. I am carrying, my lord, some judgments which say that 42 has complete.
His argument is to the extent
Yes,
that
my
the
lord.
wording is
Applications, not
So
appeal.
it will be.
Yes, my lord. Even if I may keep that aside, my lord, the judgment, my lord, which my learned senior friend has relied upon, my lord, 2007 1 SCC, my lord, if lordship takes up that judgment, I intended to rely on it as well. Because, my lord, it actually clarifies the situation. While it may look like it goes against me, it is also in my favor.
2007 1 SCC.
Yes,
right?
my lord. My lord, if lordship has a copy.
I have.
My lord, paragraph 9, my lord, of the judgment, the issue, my lord, here is having regard to the definition of court as contained in section 21E, the court of principal civil court should be held to be not empowered to hear an appeal against an order of the arbitral tribunal insofar as section 37 of the act is concerned. In the facts of this case, my lord, what happened, my lord, they filed a section 37 before the Patna High Court, claiming that this is the court of exercising ordinary original jurisdiction. And, my lord, it was held that no, a section 37 2B, my lord, which if lordship recalls, I had argued it yesterday, is going to be before a court within the meaning of section 21E. And that has been held here. However, Patna High Court did not have the ordinary original civil jurisdiction, and it was held that no, you cannot come before the Patna High Court. You must go before the district court. That is what the judgment is. And additionally, my lord, there are two paragraphs, paragraph 26 and 34, which say that 42 does not apply to an appeal. Without, my lord, that is not the issue, my lord, in this judgment. It is, I would say respectfully, it may be an obiter. It may not be the ratio. The ratio essentially is that section 37 2B appeals would always be before a court within the meaning of 21E and not the High Court. Now, my lord, the contention of the appellant is that this is the court having the jurisdiction within 21E. And for that, my lord, the appellants rely upon supplementary affidavit clause 12.1 of the development agreement. My lord, it says, I will read clause 12.2, my lord, at page 52 of the supplementary affidavit. If lordship reads it with me. the parties agree that pendency of a dispute between them, so as my lord, clause 3.12.3, Lordship. In the event that the parties cannot resolve or settle a dispute through any of the means described, the courts having territorial jurisdiction over the said premises and the High Court at Calcutta shall have jurisdiction. My lord, this is, my lord, I believe, Lordship, I do not need to show judgments to indicate that parties cannot agree to confer jurisdiction on a court which does not have it. It is simply an agreement where the recitals indicate that which court will have jurisdiction. Clearly, for the purpose of this development agreement, my lord, and I will show judgments to that effect, that where it is a case of a development agreement, the principal court having jurisdiction is always where the land is situated, because it is a suit for land. And here they have also indicated having territorial jurisdiction of the said premises. The premises is at Rajarhat. And my lord, section 9, it had been filed by me. Yes, it is a pre-arbitral proceeding. I do not have a hard copy of the application, my lord, but I can produce it to your lordship whenever I'm giving my affidavit. At paragraph 34 of my application, section 9, I have pleaded that this court has the territorial jurisdiction at Rajarhat, and they have filed a written objection. There is no denial. Today they come and say that I had filed the application and therefore they had not submitted to the jurisdiction. That, my lord, may not be the correct way of looking at it. They had filed a written objection where I have specifically pleaded that this is the court of territorial jurisdiction in tandem with, my lord, clause 12.3 of the agreement. They could have raised, my lord, the issue of lack of jurisdiction of the commercial court at the time of the pre-arbitral stage as well. On the contrary, the orders passed by the learned commercial court has time and again been accepted. In fact, my lord, the first order that was passed, my lord, 24th April, it was passed on consent, because both parties had agreed that yes, my lord, what happened is I am the landowner, I have a 40%, they have a 60%. It was agreed that no further alienation of the flats would happen unless I am being made a confirming party. Let's separate thing, I will not get into the merits that was not followed, but however, it was agreed on consent. At all times, they had submitted to the jurisdiction. Now, my lord, it also says, clause 12.1, the arbitrators will have, my lord, 4 lines from the bottom. The arbitrators will have summary powers and will also be entitled to set up their own procedure, which, my lord, the Arbitration Act contemplates. And the arbitrators shall have the power to give interim awards, my lord, Arbitration Act. The place of arbitration shall be at Kolkata and language will be English. Now, this is very clear that this is simply the place and the venue. It is distinguished from 12.3, which indicates the seat. And the seat, my lord, draws from the fact that this is a suit for land, because it involves, my lord, rights emanating from a development agreement between the parties, where, my lord, the developer is specifically claiming to be in possession. My lord, I will rely upon Shunti Banerjee, some New Age Realty, 2011. My lord, this is a judgment, my lord, of this honorable court lordship. My lord, here, my lord, what happened? The issue was whether section 11 would be before Calcutta High Court or before the Madras High Court. But it arises out of a development agreement. One of the parties came here to file section 11, claiming that there is cause of action. Parties had entered into the development agreement in Calcutta, and therefore Calcutta High Court has the power to entertain a section 11. This is not even on section 9. But, my lord, Justice Banerjee went on to explain why section 11 over here could not be entertained, because in a case where rights are emanating from a development agreement, it is always a suit for land, and therefore Madras High Court will have the jurisdiction to entertain section 11. And, my lordship sees paragraph 1, present request for constitution of arbitral tribunal for reference of the various objections which have been taken by the first respondent, my lord, 4th line. The primary one is that the petitioner herein, if it were to file a suit on the basis of the claims apparent it would be a suit for land since the petitioner's claim is inextricably connected to the land in Coimbatore that the parties had agreed to develop. My lord, now comes to paragraph 11, which is essential. Section 1112B of the 1996 Act, read with Section 21E, thereof, would imply that a request for constituting an arbitral tribunal for a reference may be made by a party to an arbitration agreement to a Chief Justice presiding over a High Court, which would exercise superintendence over the civil court authorized to receive an action. So, my lord, Section 11 powers are also, my lord, connected to the principal court having the actual jurisdiction to entertain a Section 9. That was what had followed from his lordship. Section 21E provides that a court would be competent to receive an application under the Act if such court were competent to receive a suit. Since 1996 Act does not specify any further, it is the general law relating to the institution of suits that would govern the matter, my lord, under CPC. A suit can be carried to a particular court either on the basis of the citus of the cause of action or on the basis of the citus of the defendants, which is the general law. My lord, kindly sees, unless it is a suit for land, which is an exception carved out, my lord, which is why even clause 12, my lord, letters patent carves it out. It cannot be granted. It is an exception. When it is a suit for land, it has to be, my lord, at the place where the land is situated, which makes it an exception under CPC. My lord, para 12, if a suit is a suit for land, a part of the immovable property being the subject matter of the suit has to be within the territorial jurisdiction of the court for the court to have any authority to receive the action. So, my lord, read with this, my lord, I shall complete this, my lord. If a suit is regarded to be a suit for land, the citus of either the cause of action or the defendants to the action would be irrelevant for the purpose of territorial jurisdiction. The principle in section 16 to 20 of the code is the same as reflected in clause 12 of letters patent, at least in such regard, which, my lord, I just said. Now, my lord, kindly comes to lordship at para 21. A development agreement by its very nature has to be inextricably connected to the land that it relates to. There is no dispute that it is a development agreement relating to Coimbatore property that the parties fight over. It may be true that the petitioner herein is in possession of the property, but such possession is not by virtue of any immediate right or title relating to the property, but only by virtue of a development agreement itself and the obligation of the petitioner to perform in terms thereof. My lord, if lordship sees this, reads this judgment, my lord, with clause 12.3, my lord, of the development agreement, it becomes clear, my lord, it is irrelevant whether any cause of action has accrued within Calcutta, whether the parties have agreed to include it in their recital that, my lord, High Court will have any jurisdiction, whether, my lord, the place of arbitration making it in Kolkata has any bearing. Nothing has any bearing, lordship. Because, my lord, this is a development agreement. They claim to be in possession in their statement of defense. And the land is in Rajarhat, which is also included in this recital. Territorial jurisdiction over to entertain and determine all actions. And, my lord, read with their written objection. I'm not carrying a copy, my lord. I have it in my soft copy, lordship, where, my lord, if lordship permits me, I will read it out. My lord, paragraph 34 of my written objection was where I said Rajarhat Commercial Court has the jurisdiction. They have averred in paragraph 11 of their written objection, I deny that the development agreement has been terminated so and so. I deny there has been dishonest or corrupt behavior. I deny there is any cause of action. I deny there is any prima facie case to pass interim order. No denial. No denial on whether the court at Rajarhat, my lord, has the territorial jurisdiction to entertain a section 9. Now, lordship, in addition, my lord, to what I have just relied upon, my lord, I have two more judgments to show, lordship. There is a Supreme Court, lordship, on the same proposition, 2016. Let the
Yes, not answered his objection.
I beg
Chaudhary is here.
My lord, with the leave of your lordship, my lord, may I senior, please.
Chaudhary, Mr. Sen has raised an objection to 42. He is saying that as far as 42 is concerned, only applications are to be looked into. Appeal can be filed in any forum.
That's Justice Sinha's judgment was
That's
there.
what he is relying upon.
Yes, but this is
And he says since this is an appeal,
yes.
it is maintainable.
So, Lord,
We are
I
on
made
the
the mistake
maintainability
of
part.
coming to see what she was doing. I'm on legs before Justice Kapoor. Lord, from 10:30 in the morning, His Lordship has just got up for 1 minute, and I came to see what
Don't
was.
worry, I'll get up for the entire day now.
No, no, Lord, please permit her to
I'm
continue.
going to get up.
Oh, Lordship is going to rise. I'll do it tomorrow, Milord, in that case.
Not tomorrow, Monday.
Monday, Milord. I'll continue on Monday. Milord, it's absolutely, I'll just indicate the point. 42 doesn't come into question here. Because if your Lordship looks at the section.
Your Lordship need not bother on that.
No, 42 doesn't come into question.
Very good. So, well, one point is gone.
So 1 point is gone.
Yes,
One point is gone.
42 doesn't come into question.
So, your Lordship
because
need not more think about how to come out of Supreme Court.
Section
Your
37.
Lordship's work has been lessened.
No, no. Section 37 for an appeal goes to Milord court within 2(1)(e).
Yes. I have also said that.
That court within 2(1)(e) is Milord the commercial court Rajarhat because it's a suit for land. Number 3, they have filed the appeal from the main order in the Rajarhat court, suit for land. I don't even want to go into 42. Much water has flown since Justice Sinha's judgment, but it's a Supreme Court judgment and there is no contrary judgment, so it is binding on all of us. So I don't want to go into 42. When I saw the petition, I knew Mr. Sen would come and cite that judgment. So we have prepared ourselves to, Milord, give up that point and argue the rest. It's Milord, he under 37, appeal goes to court. Court 2(1)(e). 2(1)(e) court. 2(1)(e) court is commercial court Rajarhat because it's a suit for land and only that court. And he has approached that court first. Even if 42 is not a bar, principle of committee of courts and forum shopping should be a bar. He's filed an appeal from the main order has got, that appeal is dismissed. So, Milord, this is the situation.
But I can answer this. Milord.
Yes,
I've
got many judgments.
Yes, those suit for land judgment, but I don't think my learned friend should multiply on that.
Just take down.
I will deal with the point that despite being a suit for land, this court will have jurisdiction. I also concede that it is a suit for land.
The timing of the appeal is to prevent me from.
No. All those submissions, but my learned friend should not make. Those prejudicial submissions we will take care of later.
May I have my lord's leave?
Yes. Learned counsel for the petitioner.
বললেই পারতো আমরা একটা রাজারহাটের আমি এখান থেকে করতাম নি হয়ে গেল
37 2B, right?
37 2B.
37 2B. Full stop. Learned counsel for the respondent states that the learned senior counsel for the respondent states that the present petition is not maintainable. Full stop. Let the issue of maintainability be decided first. List for further argument on Monday.
Monday, will your lordship kindly fix it at 12:30 or something, at 12 o'clock? Anytime.
Fixing a time becomes very difficult. Then it gets blocked.
This might happen, my lord. They'll have to go. Yesterday also, my lord.
There, my lord, even if my lord Mr. Chaudhary may not be here, my lord, I think Mr. Chaudhary will also be here, lordship, on that day.
Let us be understood, my lord, that their point is over.
My lord, my lord, on Monday we'll complete. My lord, I am not.
Yes, I'm not stopping you.
Grateful, lordship.
The proceedings are going on, my lord. So I am also facing the proceedings there.
But of course, they have to face the respondents in the arbitration.
No, I will show, my lord, how my lord, we can. These orders are on the face of it. I've given your lordship an example. I am saying that the same arbitrator in the first order is saying evidence is necessary, and the very next order, the security is coming in.
These things can't be.
This is something your lordship will not get
Considered it now, lordship.
in an order 38 rule 5 principle.
Yes, Mr. Banerjee.
Lord, there is one matter, my lord, where Mr. Das is also there. Item number, my lord,
Not today.
10. No, I'm saying, my lord, not today, understand, but tomorrow I'm not there. May it be on Friday or Monday, my lord. Grateful.
Monday, Tuesday.
Item number 10, my lord.
Tuesday, let's keep it.
Tuesday.
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 My lord,
Great.
my lord, next item, my lord, I'm paying for time to file, my lord, for extension of time to file reply, my lord. If you lordship, my lord, pass that order. Next item, my lord.
Let's see it on Tuesday, whatever it is. Monday.
Monday.